talk more about it with our guest, criminal defense attorney John Mobley, who's actually in South Carolina, Colombia, South Carolina there. John, thank you for being with us. What are your thoughts as we've been watching the sentencing hearing today?
Well, I got to call it like I see it when I see these types of things. Creighton was just laying the smack down with his recitation of the facts. He clearly anticipated what the defense's position was going to be. He clearly knew they were going to try to, argue some type of mitigation, argue that, although Fleming pled guilty, and he admits committing some conduct, he was not in as deep as the prosecution would, like the judge to believe. And I think Debbie's got an uphill battle. She's trying to get sympathy for the devil in this case, where I just don't think that dog's going to hunt. The conduct went on for so long and was such an involved and deliberate scheme that I think it's difficult to believe that he was not all the way in. And quite frankly, even if he wasn't all the way in, the fact that he was engaged in this type of conduct as a practicing licensed attorney, that is something that in this state, judges do not like. So she got an uphill battle. She got a job to do. But I don't think it's going to be the result that she wants. And I want to be clear, the two goals that the defense is going to have in this case is to, one, minimize his exposure from the standpoint of the length of a sentence. And the second goal will be to get that sentence run concurrent, meaning with the same time as the 4-year federal sentence. I think that it is likely that the judge will make the time concurrent, but federal sentencing is different than state sentencing. In federal court, the amount of time you're facing under the guidelines is solely determined by the amount of the loss that you're held accountable for. In state court, it's wide open. You can get anywhere from that minimum to that maximum, and so his exposure is much greater than that 4-year federal sentence.